Chapter 5, Legal Liability. Audit professionals have a responsibility under common law to fulfill implied or expressed contracts with clients. That basically just means that this common law is what has been set down by the court system in deciding cases versus what's been enacted by legislatures. They're liable to their clients for negligence and or breach of contract should they fail to provide the services or not exercise due care in the performance of those services. Despite efforts by the profession of CPAs to address their legal liability, both the number of lawsuits and the sizes of awards for plaintiffs in lawsuits are high. These are some of the contributors to the changing legal environment. You've got growing awareness of financial statement users, increased consciousness of the SEC, complexity in business, which is reflected in complexity in auditing and accounting functions, which leads to more mistakes, just a general increase in litigation, and being a society that's very litigious. With global recession and tough economic times mean people are more likely to pursue judgments. When someone sees a large court judgment that's been set down against a CPA firm, that increases the likelihood that future plaintiffs will want to recoup money like that as well. And also, obviously, CPA firms will generally try to settle out of court to avoid the cost of litigation, but settling out of court also provides another incentive for would-be plaintiffs to bring cases. And the fact that judges and jurors have difficulty understanding technical accounting and auditing matters makes it difficult to defend against those types of lawsuits. Okay, so obviously there's a difference between business failure, audit failure, and audit risk. So business failure occurs when a business is unable to repay its lenders or meet the expectations of its investors because of economic. An audit failure is when an auditor issues an incorrect opinion from a failure to follow generally accepted auditing standards. So basically, auditor not doing his job or her job. Audit risk is the risk that the auditor fails to find material in a statement and issues an unqualified opinion. So that audit failure and audit risk are not the same things because audit failure implies some failure in following the generally accepted accounting or auditing standards, whereas audit risk allows for the possibility that you followed all of the correct standards, but even in doing so, you still failed to find what would be considered a material misstatement in the financial statement. So these are some of the legal concepts affecting liability for accounting personnel and CPA specifically. The prudent person concept is just the idea of what would a prudent person do. So basically, what would your average, normal, intelligent person acting in the same position, what would they do? Having liability for the actions of others comes up in the concept in the context of any type of professional firm where you've got a lot of people working on the same project and you only have one person signing off on it. And then lack of privileged communication just means that like an attorney-client relationship involves communication between the attorney and client that is privileged. So in other words, it's not going to be revealed. Not having that same privileged or protected communication between auditors and the people that they audit changes the dynamics of the system quite a bit. So these are some of the terms related to negligence and fraud. You have ordinary negligence, gross negligence, constructive fraud, and fraud. Ordinary negligence is the absence of reasonable care that can be expected of a person in a set of circumstances. Gross negligence is the lack of even slight care, and it's tantamount to reckless behavior that can be expected of a person. Constructive fraud is the existence of extreme or unusual negligence, even though there was no intent to deceive or to do harm. So basically, you're not intentionally committing fraud, but because of your extreme negligence, we're basically going to say that you committed fraud because of the results of what happened. And then fraud, of course, occurs when a misstatement is made, and there is both the knowledge of its falsity and the intent to deceive. So these are some of the terms, again, affecting CPA's liability. You've got contract law, which governs the contract between CPAs and their clients. Breach of that contract would be when a CPA fails to do what they contracted with the client to do. A third-party beneficiary would be someone like a user of a financial statement who's relying on the information contained in the audit report. And so the contract is between the auditor and the client, but there are third parties that are affected by that contract because obviously, depending on how well that contract was performed, other users of financial statements will be affected by the outcome of that contract. So common law, statutory law, like I said a little bit earlier, common law basically comes down through court decisions. Statutory law is set out by the legislature in statute form. Joint and several liability basically means that if a defendant is convicted, or no, I shouldn't say convicted, if they lose a lawsuit, then they could be liable to the client for the full amount of liability, regardless of whether they were one actor among many. So, let's say you have 5 audit partners who are part of this audit, or auditors on this audit. The client sues only one of them for whatever reason. That one person loses the case. That one person could be liable for the entire amount of the liability, even if each of those other 4 auditors were partially responsible for it. Separate and proportionate liability is basically where you divide the amount of total liability between each person that played a part in that process and who was responsible for it, and you allot whatever percentage of liability to each person based on their respective percentage of fault for the situation occurring the way that it did. These are just 4 major sources of auditors' legal liability. They cover some of the things that we already talked about. One important one that I haven't really talked about is the fact that you do have criminal liability in some situations. So obviously, civil liability would mean a lawsuit, you're being sued. You're really only thing at risk is money. Versus criminal liability, where you run the risk of being convicted in a criminal court, and there are possibilities of not only fines but also perhaps loss of freedom and imprisonment. Liability clients is the most common source of lawsuits against CPAs. So this would be clients who are unhappy with the performance of duties, feel that there was a breach of contract by the CPA firm, and so the clients themselves bring the action against the CPA. these are some of the defenses against a client suit. We've got lack of duty to perform. Just means the CPA firm claims there was no implied or expressed contract with respect to whatever they're being sued for. Non-negligent performance means CPA is asserting that they did their part, they complied with their contract, and so they're saying basically there was no wrongdoing there on their part. Contributory negligence exists when the auditor claims the client's own actions either resulted in the loss that is the basis for damages or interfered to such a degree with the conduct of the audit so that it prevented the auditor from discovering whatever the necessary facts were to do the job correctly. And absence of causality or causal connection is basically saying that there is no close causal connection between the auditor's failure to show to follow auditing standards and whatever the damage suffered by the client is. Okay, so we've got another issue in auditor liability is liability to third parties under common law. The Ultramar's doctrine comes down from a case involving Ultramars, and it basically says the creditors, or the facts of that were that the creditors of an insolvent corporation relied on the audited financials and subsequently sued the accountants, alleging that they were guilty of negligence and fraudulent misrepresentation. The court held that the accountants had been negligent, but ruled that accountants would not be liable to third parties for honest blunders beyond the bounds of the original contract unless they were the primary beneficiaries. I think that's fairly straightforward. Another concept here that's important to understand is what the foreseen users are, and that basically means there are certain parties that if I'm an auditor, then I assume the firm that I'm auditing, if they're a publicly traded company, I assume there are certain users that are going to use the fruits of my labor. So potential investors are possible foreseen users because it's logical that and it makes sense that they would use that information. So those are people that I would potentially have a liability. I would have potential liability for them relying on my work if I had done my work in a way that caused or created liability, because I can foresee that they may use my work. So basically, to have any type of liability to a third party who's not part of the contract between myself as the auditor and the client whose statements are being audited, these other users, these third-party users, have to be a part of this foreseen users group. So there was a case against Arthur Anderson that decided that to be liable, the auditor must know and intend that the work product would be used by the third party, this is the foreseen user, for a specific purpose, and the knowledge and intent must be evidenced by the auditor's product. The restatement of tort states that foreseen users, and this is basically essentially a statutory restatement of tort law, states that and tort is just what you call these actions when there's a lawsuit like this. A tort means just a wrongful act. So if there's a civil action that's going on where you're suing someone, you're suing them for some tort that they committed. It's the kind of the equivalent of a crime, but instead of being a criminal offense, it's a civil offense. Anyway, the restatement of torts states that foreseen users must be members of a reasonably limited and identifiable group of users that have relied on the CPA's work. And it basically boils down to a foreseeable user being any user that the auditor should have reasonably been able to foresee as a likely user of the client's. So here's just a kind of a flow chart from narrow, what's described in the Ultramars case, to a more broad definition of a foreseeable user that you see here at the bottom from the Rosenblum case. So the Securities Act of 1933 imposes kind of an unusual burden on the auditor. So it basically says any third party who purchased securities described in the registration statement may sue the auditor for material misrepresentations or omissions in the audited financial statements that were included in the registration statement. Users only have to prove that the audited financial statements contained a material misrepresentation or omission. The auditor must demonstrate that an adequate audit was conducted, or a portion of the plaintiff's loss was caused by factors other than the financial statements that were apparently audited incorrectly. Under the Securities Exchange Act of 1934, the liability of auditors centers on the audited financial statements issued to the public in annual reports or submitted to the SEC as part of the annual Form 10-K reports. So as part of the anti-fraud provisions of the 1934 Act, and also decided in a common law case, Hochfelder versus Ernst, U.S. Supreme Court ruled that scienter, which is the knowledge and intent to deceive, is required before CPAs can be held liable for violation of Rule 10b-5. So that's the part of the Securities Exchange Act talking about fraud. So obviously that's a good thing for CPAs because that limits some of the liability. So the SEC has power in certain circumstances to sanction or suspend even practitioners from doing audits for SEC companies. So that's quite a bit of power. In recent years, the SEC has temporarily suspended a number of individual CPAs from doing any audits on SEC clients for certain perceived lapses in professional responsibility. So another act that's somewhat important, at least in knowing your legal liability, is the Foreign Corrupt Practices Act of 1977, which makes it illegal to offer a bribe to an official or of a foreign country for the purpose of exerting influence and obtaining or retaining business. Obviously that one's not directly related to auditing, but can come up in the course of doing business. And then, of course, you've got the big accounting, or probably the biggest piece of legislation ever to affect the accounting world, Sarbanes-Oxley Act of 2002, which requires the CEO and CFO to certify the annual and quarterly financial statements filed with the SEC. Management must report its assessment of the effectiveness of internal control over financial reporting, and the auditor must issue an opinion on the effectiveness of internal control over. So now let's talk a little bit about criminal liability for accountants. This is just a brief summary under the pieces of legislation and common law that we've already talked about. It may be helpful to look at this slide while going over the homework or taking a look at the quiz, as it sets out a lot of information in a short period. So under the Sarbanes-Oxley Act, it's a felony to destroy or create documents to impede or obstruct a federal investigation. So obviously, if it's a felony, that's a criminal liability and can be a significant amount of. So these are auditor defenses against suits by a client, third parties under common law, and under both the 1933 and 1934 Securities Act. Basically, you see with the client suits, you have all of those potential defenses under third-party common law. You don't have contributory negligence by client. Securities Act of 1933, you basically only have non-negligent performance as a possibility. And then under the 34 Securities Act, again, contributory negligence by client or third party does not apply in that situation. Okay, so these are just important actions, I guess, to take, or proaction in order to avoid potential liability. The standard setters, so the IAASB, the AICPA, and the PCAOB constantly need to look at and revise, and theoretically this is what they're doing, but constantly revise and look at standards in order to set standards that minimize the likelihood of subjecting auditors and the profession in general to legal liability. Educators such as professors, the AICPA, and basically anyone who educates someone who reads financial statements should help educate those people as to what the meaning of an auditor's opinion is and the extent and nature that one should rely on an audit opinion when looking at financial statements. So obviously it's important for a professional organization to police its own membership. I think that's why the AICPA and the PCAOB, in the past they've made progress in dealing with problems of inadequate CPA performance, but more rigorous review of alleged failures is still probably needed in constant revision. Since the 1990s, there have been several changes in state and federal law that have favorably impacted the legal environment for accountants and CPAs. The passage of the Private Securities Litigation Reform Act of 1995 and the Securities Litigation Uniform Standards Act of 1998 significantly reduced potential damages in federal securities-related litigation by providing for proportionate liability in most instances. So that makes it harder to go after one individual and tack all the liability onto them. So that reduces the amount of individual rewards of damages, which obviously if there are less damage rewards going out, there's less incentive created to bring litigation. And then as just individual CPAs, these are some of the things that you can do to avoid personal liability for yourself. Try to deal only with clients possessing integrity. Obviously, there's tons of red flags. If you see clients that are unethical, I think it's most dangerous in a situation where maybe you're just starting out and trying to get clients. And losing a client could be a substantial burden for you financially. I think that's when you kind of have to have already made the decision that you're going to only deal with clients with integrity. You want to make sure you're hiring qualified personnel because you do have liability for people acting as your agents. You want to try to follow the standards of the profession to the letter. Maintain independence. CPA firms need procedures to evaluate the integrity of clients and should obviously disassociate themselves from clients that lack integrity. And like I said, making that decision before it comes up is usually best. And of course, always trying to make sure that you are independent and that the people that work with and for you understand the importance of independence as well. These are some more things that can be done. And basically, these are tied to the last slide, obviously. One of the biggest things here is understanding the client's business. It's a real temptation to jump into and do an audit of a company where you don't understand their business at all and you don't take the time necessary to gain an understanding of it. And lacking that knowledge of industry practices can lead to audits that end up being audit failures. And a lot of liability for auditors, at least in the recent past, has come up when auditors try to take on audits and don't have that industry knowledge and don't take the time to come up with it. Another thing that is vitally important, maybe not as important in avoiding lawsuits, but definitely important in winning them if you end up having to go to court, is quality audit documentation, which we will talk about more in coming chapters. But this is basically what you would use to defend yourself in court, is the documentation from your audit. And this is basically the proof that you have that you followed all the standards that are required of you. Some more things that you should do: obviously carry adequate insurance, try to get legal counsel if you need it, and organize your original business with an organization that grants limited liability, such as an LLC or an S Corp or something of that nature. Auditors are often liable when they are presented with information indicating a problem that they fail to recognize. Obviously, auditors need to strive to maintain a healthy level of skepticism so that they can recognize misstatements when they do come up, because obviously they will at different